I'm on mute. Good afternoon and welcome to the Agenda Equality Maine weekly live broadcast. If you're watching on Facebook or YouTube, feel free to use the chat to let us know where you're watching from and what questions you have. An Equality Maine staff member is monitoring the chat and we'll make sure to get your questions to us. Happy Friday. My name is Matt Moonin. My pronouns are he, him, and I'm the Executive Director at Equality Maine.
And I'm Jake Karras. My pronouns are he and him, and I'm the Grassroots Advocacy Coordinator here at Equality Maine.
And today we're joined by Sarah and Meryl, our ASL interpreters. Thank you so much for helping us out today. So Jake, why don't you get us started with some updates?
Thanks, Matt. So we have some good news happening around the country in an otherwise difficult legislative session coming out of the Midwest. So in North Dakota, the governor has vetoed the state's sports bill. So the Republican governor there, Doug Burnham, has vetoed the state's ban on transgender athletes after it passed both chambers and the North Dakota legislature in recent weeks. The governor noted that the state high school athletics governing body already has an existing policy that governs trans athletes and that the bill would interfere with the existing rules. There was some concern that the legislature might be able to override his veto, but their chance passed yesterday and they did not do so. So the bill is done with, which is great. And then we also have a similar thing happening down in Kansas too. The Democratic governor there, Laura Kelly, had vetoed the state's ban on trans athletes. And similarly, the legislature did not pass this bill with a supermajority, which means that there's no chance for that veto to get overridden either.
Quite the hot issue all over the country that we're facing here in Maine. Nice to see some good news coming out of a couple of other states on that. So let's turn to today's topic for today's show. And we have two very special guests who are joining us to talk to us about the topic. First, we have Mary Bonato, who is the Civil Rights Project Director at GLAD, which is GLBTQ Legal Advocates and Defenders. And Mary, welcome to the show.
Thank you, Matt. Great to be here.
And second, we have Holly Hollman, who is the General Counsel and Associate Executive Director at the Baptist Joint Committee for Religious Liberty in Washington, D.C. Holly, welcome to the show.
Glad to be with you. Thanks.
So, Jake, do you want to start us off with some questions?
Yeah, so I guess before we get started, we're talking today about a pending Supreme Court decision called Fulton v. City of Philadephia. And before we go into the legal analysis of what this is, Mary, could you just tell everyone what happened in Philadelphia a few years ago that led to this case?
Sure, and I'll try to stay out of the weeds. You know, in the broad brush, there are children who are taken into custody in Philadelphia because they can't live at home. Those children are the responsibility of the city of Philadelphia. The city of Philadelphia needs help identifying and recruiting families, screening them, and ultimately supporting those families who may take children for, a small period of time or longer as foster parents. And as part of this process, Philadelphia, in its contract with its contractors, like Catholic Social Services in this instance, requires that the contractors abide by a local non-discrimination law that is inclusive of, among other things, sexual orientation, gender identity, marital status, and so on, but really it's sexual orientation here. And Catholic Social Services, it came to light that they were just not screening same-sex couples because of their views about marriage and family, and also who should be raising children, which is part of their views about marriage and family. And when this came to light, there were some attempts to say, can't we work this out, and ultimately they refused to change direction. And so even though the city continues to work with Catholic Social Services and on other contracts on this one, since they exclude, among others, same-sex couples, the city, suspended and then ultimately did not renew that contract. And Catholic Social Services sued. Ultimately, they lost in the appellate courts and so on, and they took their claim to the U.S. Supreme Court, claiming that they have a right to act in accord with their religious beliefs, including when they're doing work for the government under a government contract. And so this is a very deep challenge to the applicability of non-discrimination laws, because it's arising in a context of the government, where the government generally has an obligation to be open to everyone. Like that's what the government is. It has to treat all comers. So it's that context, and it's also it's an employee of the government. So very, potentially profound implications of this case if they are allowed to rely on their religious beliefs not to serve certain people.
Yeah. Okay. Well, Holly, let's turn to you. A lot of folks in our community, in the LGBTQ community, get a bit nervous when they hear religious liberty, and they tend to think that it can mean a license to discriminate. But your organization sees things differently. Can you talk to us about why the BJC sees the Fulton case as a First Amendment issue?
Sure. And thank you so much for letting me be here and be with you all. Just a little by way of background about BJC as a religious liberty organization. We're an education and advocacy organization, been around 80 years. We're dedicated to faith freedom for all. And we come from this historic Baptist perspective that you have to go deep in if you're not a religious person or not a history person, you got to go deep into history and theology to understand. But it comes from a place that really puts a high emphasis on individual conscience and autonomy. And so we believe separation of church and state is the best way to protect religious freedom for all people. And religious freedom means protecting the free exercise of religion, people's belief and their exercise, but it also means the government cannot advance religion or choose between religions to promote it. And this, of course, is a very complicated area of the law. So BJC is dedicated to working hard to get religious freedom right as the best way to protect religion, but also to protect government. We are involved in this case as a friend of the court. So BJC is involved in promoting religious freedom in our perspective through education efforts, through legislative efforts, monitoring the executive branch, and then in litigation, not bringing the cases, but intervening in the cases as friend of the courts where we can. And in Mary's very excellent summary of this difficult case, she emphasized this government environment. As this audience knows, there is tension between some people's religious beliefs and activities and claims of non-discrimination. But in the government format, in the government forum where government is charged, they should be able to set their rules and set their rules for contractors. And so we filed a brief taking that position. We were joined by other denominational groups, Christian denominational groups. As your audience should not be surprised, of course, there's a wide range of religious views on human sexuality. And it's just very unfortunate that too often people hear the word religious liberty and think anti-gay or somehow relate just to this important kind of thing that we're trying to work out. How do we protect religious freedom and non-discrimination? But this case is very important because at the very least, government should be able to direct its own efforts of non-discrimination. And in that effort, it would be very difficult to accommodate a contractor's perceived right to not follow the contract and instead their own religious precepts that are at odds with the government's interests.
Holly, thanks for that background. Mary, I want to just turn to you quickly again, just to reiterate the position I imagine a lot of folks in our community are a little bit more familiar with about what the argument GLAD is making here. So could you talk a little bit about your brief and how you see this as an equal protection issue?
Well, actually, I have to say that there's a lot I agree with Holly that these are really important issues, and faith is important, and it is important for pluralism in our nation that we respect people's faith and exercise when we can. But this is a case where, we think there's not a great argument for faith predominating when you're a government contractor doing the government's work for kids in government custody. So what we talked about here, given the stakes of the case as I just laid it out and as Holly has also laid out, what we said is, look, there have been a series of cases really starting with Romer versus Evans in 1996, that's Colorado's Amendment 2, and then moving forward through sodomy case and DOMA and marriage and even post-marriage with Masterpiece Cake Shop. And, to use the Supreme Court's words, LGBTQ people have moved from outcast, their word, to being able to participate in society. And time and again in those other cases, they've of course wrestled with, religious and moral objections to LGBTQ people and our existence and our, whatever. So to now sort of switch gears and say, oh, now we're going to actually prioritize religious and moral and other objections to LGBTQ people, sort of takes that promise, that incipient promise of equality, and says it's not real. And that's extremely concerning, right? So I was trying to remind them about what they'd done. And then in addition to talk about how, it's a fact that a great deal of discrimination that is directed at LGBTQ people is couched in religious terms. And, we provided a variety of examples of that in the brief, just to say this is real and we're not just saying that this is a danger, like here's lots of examples of the danger. Like we very much want to respect free exercise, but discrimination is often framed in these terms. And actually the real pitch to the court was at the end to say, do not constitutionalize an exemption here. Do not say that government contractors are free to elevate their religious views over the government contract and the government obligation to serve everyone. There are tensions, and maybe a better way to resolve this tension is through the democratic process, which can be much more nuanced than a very blunt, categorical constitutional exemption. So we were very grateful to have Equality Maine on this brief, along with 26 other, state and regional LGBTQ organizations to make that point. Not that we are hostile to religion and to exercise of faith, but we cannot also, in the course of doing that, abandon the promise of equality and, what we call equal citizenship to LGBTQ people.
So this question is for both of you. We would assume that you listened to the oral arguments. They were held in November, actually the day after the presidential election, and even before we had a declared winner in that presidential election. So it was the very next morning. Holly, why don't you start? Can you share with us reactions to what you heard as the lawyers made their case and as the justices asked questions?
Sure. I think there are a few takeaways I think I would highlight. I think I agree with Amy Howe, who's a great reporter at SCOTUS blog, who could overall say, look, this court seemed very sympathetic to Catholic social services. I think that's kind of a general feeling that people had, that this court would be trying to find a way to honor their Catholic beliefs, particularly because of some of the softer facts about their long-serving, their long practice of being involved in social services in the area. That and this famous language, which I'm sure you all have heard and Mary knows very well, from the Obergefell case, to where the court recognized recognized marriage equality, and at the same time said, of course, there needs to be certain respect giving or honorable reasons that people would have different religious views. So I think the court was kind of struggling in how they could make good on that promise in a way here. And so that's the hard news, I think, for this case. I would say that the best news, the possible, there are a couple of things that might soften how the court comes out. One would be remarkable, but it's possible that the court really could focus on this government environment and have a very narrow decision that doesn't settle the overall clash, but says in this environment, Philadephia certainly has the right to set its requirements for government contractors. There was a lot of oral argument based on that, saying, isn't this a government program administered by the government, funded by the government, and really honing in on the huge implications of letting a contractor shift the criteria that they are applying. Of course, religious and non-religious contractors should be welcome to the table, but they are applying secular government factors. The other issue, and I don't want to go too far in the weeds either, but at the court right now, they're struggling to find what is the proper standard for the free exercise of religion. And that is a big part of this case, whether the court will be looking to change that standard and move toward a constitutional recognition of automatic exemptions. It's what Mary was saying. It's, that's what she's trying to avoid. And I think this would be a very bad case to do that. So that if the court wants to do that, I'm hopeful they will not do that in this case, but would find a more narrow way of deciding it.
Thank you. Mary, same question. Reactions to what you heard during the oral arguments?
I think that was a great summary. The court touched on a little of everything. And, it was one of the first arguments of Justice Barrett also, who, at least what people report, I guess you can read it differently. I've heard people read it differently, but she seemed, at least people read her to be reluctant to jettison the existing constitutional standard because of the question of what you would replace it with. And right now there's lots of exceptions to the standard, but the standard is supposed to be that if a law generally applies to everyone, and it's not targeted and trying to get at religion, then it can have some sort of incidental burden on religion and still be valid. Because ultimately we're a government of laws and things are going to be taken by people in organizations somewhat differently. That standard has been under attack since it was announced by Justice Scalia in 1990. And, we are getting close, I think, to the culmination of the campaign to have a new standard. And our goal, as I said earlier, would be not this case and also not through constitutional exemption if at all possible. But the court will get there. Holly, do you want to comment on that at all?
Yeah, I was just going to say, just to let your audience know, that we were part of that religious and diverse coalition to really complain about the Smith decision and lead to RFRA. And I know it's been a long time since that was passed and a lot of things have changed and all, but we argue that even if the court reversed Smith and that Smith had problems, it was a decision that was not well founded, that still the city of Philadelphia should win. That this is a case where even if you could recognize some burden, which we would really question whether or not this is a legitimate burden since Catholic Social Services voluntarily agrees to contract. But even if you could recognize a burden on their beliefs to have to follow the contract according to the contract terms, that the government interest here in making sure that they had the greatest number of foster care parents available for these children, that there was not a single message sent that could dissuade or could somehow disincentivize anyone from taking on foster kids. That the government has the right to pursue that and to pursue it in a way that does not allow any kind of exception for its contractors. So there is a way that even if the court were to reverse Smith, that the city should still win.
Is it okay if we keep wonking out about this, everybody? Because in trying to map out. Well, in terms of mapping out outcomes, as Holly was referring to, it could be something about the unique history here. Not that that's normally a principle in constitutional law in this context at all, but, Catholic Social Services says it's been involved in providing homes to children since the 1700s. So, so they get an exemption, they get grandfathered in. Again, I'm not aware of this in the constitutional framework, but there you have it. So they're making that argument. And that would be a narrower loss. Although, again, I don't think we should kid ourselves that any sort of loss in this area will just creep out. There's another kind of loss, and this is what happened in Masterpiece Cake Shop, where there was a concern that, the Colorado Human Rights Commission had been hostile to the person's religion, the baker's religion, in the course of, sorting out that case. And likewise here, when the city of Philadelphia approached Catholic Social Services to try to work this out, I read it and I thought, boy, they were really trying to reach an accommodation. Other people read it and feel like it was, insulting them and coercion. So, it could be another case like that, in which case it becomes a one-off, just really forestalling the day in which there's some sort of broader constitutional rule announced. For us, a win looks like what Holly said, which is there's no right to discriminate here. And also there are important, other important interests, but there are plenty of ways to lose it as well, some of which are narrow and some of which are rather extreme.
Yeah, I think that point really points to what we all recognize and have to keep working on, which is there is this serious political problem, serious trust problem with this tension between religious differences and the fight for non-discrimination. And some members of the court tend to really feed off that. It's sometimes almost exaggerate that in a way to kind of push toward the religious objector. And that's what we watch, but I think it's something that should call all of us to listen to each other, to try to understand how we can be supportive of people's free exercise of religion. There are differences in religious beliefs, but understand where we come together as civil society, we have to work out rules that are respectful of differences.
I heartily agree.
So in the
I
last few
probably should
minutes that
disagree
we
to make
have
it more
here,
interesting.
Well, disagree.
I just wanted-
I can put it to you like Justice Alito. Isn't this really about changing Catholic Social Services' mind? Isn't this really because you hate their traditional beliefs? And I think there was really interesting argument there. I felt Justice Breyer did a good job really trying to work with the tension to say, look, you've got to find a way to provide services, and no one's trying to tell you that you have to endorse them from a religious perspective. But if you want to provide the services, this is what the contract requires. And that should not be seen as hostile to your religion when the government has a valid purpose it is pursuing.
Yeah, and to reinforce that point, so the idea would be, okay, Catholic Social Services, you are not endorsing anything. You are simply applying the criteria that the state and the city have already set forth for evaluating whether people meet the requirements for being a foster parent, whether their home meets the requirements. That's it. That is your job. You are simply, that's not quite a checklist. It's more evaluative than that. But that's all you really need to look at. Please do that. Leave the endorsement piece to us. You're not doing endorsing. We're endorsing by saying they met these criteria, therefore we're going to consider placing, a child in this particular family. It's a way of trying to split the baby. But I have to say, I remember a time in California when California forbade same-sex couples from jointly adopting. And yet what would happen is the state in these home studies would evaluate a couple, and they would write these glowing reports about these couples and how they should be able to adopt, whatever it might be. And then the state would nonetheless, at the conclusion of that report, say, and we recommend rejecting them. And then they'd go to court with this home study that was full of praise, but rejected them. And then the courts would grant it. And I have to say, part of me just feels a little like, still, is this really a perfect solution here? Probably not, but it may be as close as, maybe it gives us more time to define something that is more consensus-based and ultimately more workable.
We're coming up on just about 5 minutes left, so I want to just cover one last thing because there's a lot of other stuff happening around the country that that the court's ruling could impact. So whether or not we get a good ruling, it's still going to have some kind of impact on the passage of the Equality Act because it's going to define, the existing standards of non-discrimination law. So as a closing thought, do either of you have thoughts as to what the future of the Equality Act might be, whether we get a good or a bad ruling in Fulton?
Do you want me to kick that off, Holly?
Go ahead, Mary. Yeah.
Okay, so the Equality Act is a very broad piece of legislation, right? So it's employment and housing and public accommodations and federal funding, which is where this comes in, and credit and jury service. I mean, it's really bringing LGBTQ people into our nation's civil rights framework at the federal level. So obviously, supporter, right? But there's another proposal out there that I just want to say, which is trying to address this problem. It's something called the Fairness Act. I forget exactly what it's called. Fairness Act. Fairness for All, thank you. That tries to address this problem and say, let's give, anyway, they're trying to address it by creating a 2-track system that's very complicated in states, to say, if you're going to get money directly from the government, you have to treat everybody, and otherwise we're going to give money to people, and then they can go to whatever agencies they want. Anyway, I'm just trying to say, like, these discussions and debates are going to be happening alongside the Equality Act. And so I don't think there's any way to evade these discussions, and I'm not sure it's helpful to evade them, because we need to have the discussion so that we can, as Holly was saying, move forward together as a nation. Holly, you want to add?
I agree. I think it might, tilt one way or the other, right? Whichever side wins. But the problem is that we're not a country of sides. We have to work together. There's a lot of sides in this. We have to find ways to protect non-discrimination without doing damage to people's religious conscience and their space for following their religious precepts. So I agree with Mary. These conversations are going to continue. They'll be affected by the decision, but they won't decide what kind of federal legislation we could have to address all of these issues.
Yeah, and assuming there's not a total blowout, from my perspective in Fulton, a lot of the Equality Act would not be affected by it. Some of it would.
So our community is, very familiar with watching Supreme Court cases, especially in recent years. And is it safe to say that we're on a similar timeline? I mean, it's almost May 1. Are we looking at like this case coming to the very end of the court's term in June, or any predictions on when we will see a decision?
I say probably. I think it'll be toward the end. I mean, I still sat at my computer Thursday waiting in case it happened. But I imagine it'll be toward the end. And frankly, I think it's a very tough case, not only for this big issue the Equality Maine cares about and is working on, but this other larger free exercise issue that's been the court's really pushing and pulling, as we've seen in a whole lot of COVID-related cases. So there's a lot of conversation, I think, going on among the justices about what kind of standard to set, not just for this case, but for the future.
Well, as Jake mentioned, we are about out of time. Either of you have any final thoughts that you want to share before we close out?
No, I just thank you all for inviting me, having me, and setting an example for dialogue, for listening, and to keep moving forward to try to find ways to address problems respectfully. Thank you. It's great to be with you, Mary. Thanks for your work.
Yes, likewise. Nice to meet you, and thank you, Equality Maine, as always.
All right, Jake.
Awesome.
Closing thoughts?
Thank you, Mary. Thank you, Holly. Rose, who's monitoring the chat and the stream, is going to put in there the links both to GLAAD site and the Baptist Joint Committee's website. We'll say, I think you should check out the BJC's website. They have a fantastic internship program. Otherwise, that's all we have for this afternoon. We'll be back again about the same time next week to talk with you again. Hope everybody has a great weekend, enjoys the nice weather up here in Maine.
Bye. Have a good weekend.
Thank you.
Nice to meet you, Holly.